My name is Will Wyatt. I represent the appellant, City of Germantown, in this matter. This time, I would like to request 4 minutes for rebuttal, Your Honor.
4 minutes. All right, sir. You may proceed.
Your Honor, this case comes to this court on an interlocutory appeal from the Shelby County Circuit Court from the court's denial of a motion to dismiss filed by the City of Germantown on the basis of the statute of limitations. The lawsuit arises out of a slip and fall on a sidewalk in Germantown, Tennessee. The plaintiff filed lawsuit against the City of Germantown and the property owner of the property on which the sidewalk was situated. That's the Willard defendants. The case proceeded for a couple of years. Then the plaintiff non-suited while the City of Germantown had a pending motion for summary judgment, non-suited the city, refiled their action shortly after an amended complaint was filed by the Willard defendants, and the city filed its motion to dismiss. The basis of the city's motion to dismiss was that Section 20-1-119 of the Tennessee Code Annotated did not apply to avoid the bar of the statute of limitations, and that the plaintiff's claim was barred because the original answer filed in April of 2021 by the Willard defendants sufficiently raised comparative fault as to the City of Germantown to trigger Section 20-1-119. The issue before this court is whether Section 20-1-119 applies when the plaintiff refiled or renamed the city in an amended complaint that was not filed within 90 days of the first answer raising comparative fault as to the city. The city respectfully submits that it does not. The city respectfully submits that the trial court erred in denying the city's motion because after the trial court found, as the city had argued, that the original answer filed by the Willard defendants raised comparative fault, the trial court then disregarded that answer and instead relied upon the second answer asserting comparative fault against the city, the amended answer, as being the answer that triggered the 90-day provision of Section 119.
Counsel, when the first answer was filed, and let's assume for purpose of argument that, and it's the argument you're making, that it was sufficiently raised with regard to comparative fault, the city was still a party at the time, wasn't it?
That's correct, Your Honor.
So how is that really fitting within the statute at that time period?
Your Honor, the middle section of this court's decision in Towns versus Sunbeam Oster Company speaks directly to that issue. In the Towns case, when the answer that alleged comparative fault against Sunbeam and triggered Section 20-119 was filed, Sunbeam was actually a party. And
we don't have two answers, though, in Towns, do we? And there's not two different responses filed, one filed at a time period where there's not, where they are a party, and then a second one where they're not a party.
No, Your Honor, there aren't two answers filed in Towns, but the significance of Towns is Towns stands for the proposition that the fact that the comparative tortfeasor is a party at the time the answer is filed raising that party's comparative fault is immaterial to the application of Section 119. Sunbeam actually made that argument in Towns, Your Honor. They argued that 119 could not be triggered by the answer filed raising their comparative fault because they were a party at the time. Sunbeam's interpretation was that 119 required the answer allege comparative fault against a non-party. The Towns court rejected that argument and said, no, the pertinent time for determining whether an added defendant is a party is not when the answer's filed, it's when the complaint is amended. And so the fact that the City of Germantown was a party at the time that the Willard defendants filed their original answer is immaterial to the application of Section 119. And on the issue of when there are two answers filed, the Supreme Court, the Tennessee Supreme Court's decision in Bidwell versus Strait speaks to that issue, Your Honor. In that issue, or in that case, you had Dr. Strait and Dr. Colburn, who both filed answers raising comparative fault, as the Supreme Court found, raising comparative fault against Erlanger. When the Supreme Court was analyzing whether or not the plaintiff could take advantage of 119 and had complied with the requirements of 119, they made specific point to reference that it was Dr. Strait's answer, which was the first answer filed before Dr. Colburn's answer, that raised the comparative fault of Erlanger, and it was that answer that triggered Section 119, and that the plaintiff had 90 days from the filing of Dr. Strait's answer to amend the complaint to add Erlanger, and they didn't, and therefore the claim was barred by the statute of limitations.
Counsel, is there any daylight between this case and the Scales v. H.G. Hill Realty Company case, or does Scales have to be wrong for your client to prevail here?
Scales would have to be wrong, Your Honor, and the city respectfully submits that Scales was wrongly decided in that it violated, or its holding was contrary to not only the plain language of Section 119, but it was contrary to the controlling authority of towns. If we look at Scales, Your Honor, the Scales Court specifically noted that the original answer filed by Publix raised comparative fault as to H.G. Hill Realty. Then H.G. Hill Realty was non-suited. Some significant amount of time passed, and the plaintiff filed an amended complaint. A second answer was filed raising comparative fault. The Scales Court then disregarded the filing of the first answer raising comparative fault.
Isn't it the first answer, though, that's filed where they're a non-party? And that's the first time an answer is filed where there's a non-party that comparative fault is being raised as to.
That's correct, Your Honor, as far as...
And isn't that one of the three triggers under the statute?
No, Your Honor, it's not. The fact that the comparative tortfeasor has to be a non-party is a trigger, but it is determined at the time that the amended complaint is filed, not at the time that the answer's filed. That was the holding of Towns. Again, the Sunbeam made that argument, that the proper interpretation of Section 119 was that the answer had to allege fault against a non-party. Towns said no. Towns said the answer has to raise comparative fault, and you determine the party's status not at the time the answer's filed, but whether they were a party when the amended complaint was filed.
The language in 21-119A, framing the time period, the first answer, the first amended answer alleging, refers to that person's fault, right? And that's the language of the statute. Why isn't that person in A a reference back to the earlier language in the same statutory provision that says a person not a party to the suit caused or contributed to the injury or damage for which the plaintiff seeks recovery? Why would we interpret that person to mean something different than the understanding of person that appears earlier in the same sentence?
Your Honor, the Towns Court found that it does not make reference to a comparative tortfeasor at the time that the answer is filed. That it is the determinative time period is when the amended complaint is filed. Towns was decided by then Judge Koch in 2001, and it has been the prevailing case law since 2001. It has been cited with approval by the Tennessee Supreme Court multiple times. In Mann versus Alpha Tau Omega fraternity, the court cited Towns and parenthetically set forth its holding that the time for determining when a party or an added defendant is a party is when the complaint is amended. In Becker versus Ford Motor Company,
Wasn't this within 90 days of when the complaint was amended? And I'm reading Towns directly, and this is with, if we're determining status at that point, this is within 90 days.
are we talking about the Towns opinion now?
The
Are you
Towns
asking
opinion.
about the Towns opinion?
The Towns opinion.
Yes, Your Honor, it was within 90 days, but the distinction there that's critical to our case here, in Towns, it was within 90 days of the first answer that alleged comparative fault. Here, the first answer alleging comparative fault was filed long 90 days before the amended complaint was filed.
Counsel, it seems to me you're still asking us to read out that language, define that person in 21-119A as not being a reference to a person not a party to the suit caused or contributed to the injury, which is, it seems to me that that person likely refers back to the person earlier referenced in the same statutory provision. And we're talking about a person who was not a party in terms of the filing.
Your Honor, I see I'm out of time. May I answer?
Please.
Sure.
The reference to not a party, I mean, the added tortfeasor cannot be a party. That is one of the conditions that the Tennessee Supreme Court has recognized in the Mann decision for the application of 20-1-119. The significant factor, though, and the focus of not only the city's position in this case, but the focus of the case law interpreting Section 119 is that when do you determine the added defendant status as a party? Here, the added defendant, the city, was not a party. It was not a party when the amended complaint was filed. We don't take issue with the second condition from Mann as having been satisfied. The issue in this case is, did they amend within 90 days of the first answer alleging comparative fault? But back to Your Honor's question, the comparative tortfeasor being a non-party is a factor, but the the holding of Towns is that you don't look at their status as a party when the answer's filed. It's when the complaint's filed, because in Towns, Sunbeam was a party when the answer triggering Section 119 was filed. So if, in fact, the status had to be determined at the time that the answer was filed, then 119 wouldn't have applied in the Towns case as the Towns court specifically held.
Let me be clear about what you're arguing with regard to Towns. When the answer was filed raising the issue of comparative fault on the part of the manufacturer, Sunbeam was not a party at that time in the lawsuit, was it? It had been dismissed, as I understand it, from reading Towns.
No, Your Honor, it actually was a party when the answer was filed. It was very soon after the answer was filed, it was dismissed on statute of limitations argument. And then, very shortly after that, the plaintiff attempted to amend again and bring Sunbeam back in.
And that amendment was filed within 90 days of the answer asserting comparative fault on the part of Sunbeam.
Yes, Your Honor.
So how is that akin to the facts in this case, such that you rely on Towns?
Your Honor, the reason that the city relies upon Towns is because the trial court interpreted 119 as stating or as requiring that the comparative tortfeasor to be added cannot be a party at the time that the answer is filed. And that was why the original answer didn't trigger Section 119.
What provision in the original answer do you rely on to show that comparative fault was raised in the original answer? Because in reading it, I don't see that it was raised.
Your Honor, the provisions that raised comparative fault in the original answer were a series of admissions by the Willard defendants. There were allegations against the city of Germantown that the Willard defendants admitted. They admitted that the city had a duty to maintain its sidewalks in a safe manner, that they had a duty to ensure that the sidewalks did not, that no dangerous conditions were created on the sidewalks or allowed to continue, that it breached both of those duties, that through its acts and omissions, the sidewalk was allowed to become dangerous, which constituted gross negligence. The Willard defendants admitted all of those allegations without qualification, and under the Tennessee Supreme Court standard in Austin versus State of Tennessee, which was the seminal case that determined what is required to allege comparative fault in order to trigger Section 119, the court made clear that formulaic language or explicit allegations of fault or even the use of the term comparative fault is not required. It intentionally set a very low standard, and that standard being simply the answer needs to give notice of another potential tortfeasor, and it needs to include facts that reasonably suggest that the tortfeasor could have caused or contributed to the alleged injuries. And the city would respectfully submit that the admissions of those allegations by the plaintiff fits within the standard that the Austin court established, and it clears that low bar for raising comparative fault sufficient to trigger Section 119.
Thank you.
Thank you.
May it please the court. Excuse me. My name is David Siegel. Excuse me, and I am counsel for the appellee, Ms. Brenda Sands. I would like to briefly discuss counsel's argument about the Austin case, which indicates, true enough, that there is no formulaic standard when having to determine whether or not some other party that's not a party to the suit caused or contributed to the injury. That's true. I know that because I actually argued the Austin case at the Supreme Court. I also argued it at this court. And what I can tell you about the Austin case also is that the Austin case, the defendant that was sought to be brought in was the state of Tennessee. They were a non-party at the time of the allegation. Moreover, I would say that, and this goes to the affirmative defense of comparative fault, in Austin, although they didn't use the words comparative fault, which was really the key behind the Austin decision, what was important about Austin was that there was an attempt by Fayette County to shift the blame to the state of Tennessee. They actually affirmatively stated in their answer in Austin that the stop sign in question, we had alleged that there was a defective stop sign, that stop sign was owned or controlled by somebody that was not a party to that suit, which happened to be the state of Tennessee at that time. And, or it may have been Fayette County, but whoever it was one of the parties that was not a party to the suit. So what I'm trying to argue in my brief is that there is nothing that is really affirmatively stated in the answer in this case which would suggest, the first answer that was filed by the Willards, that even suggests that they're alleging an affirmative allegation of blame shifting or fault against the city of Germantown. All they've done was essentially passively admit the allegations that we had raised in our original complaint. But what's interesting also about the answer that they filed in the first answer is that there was absolutely no attempt to actually see the defenses were segregated in the answer, and I think I've laid those out in the brief. The defenses were that they actually say these are our affirmative defenses, and they actually listed as one of their affirmative defenses in the answer the plaintiffs, the Ms. Sands' comparative fault. They don't even allege as an affirmative defense the comparative fault against the city of Germantown. All they did in that answer was passively admit allegations that we had made against the city of Germantown. So I do think that this, to the extent that we're talking about the sufficiency of an allegation of comparative fault, I do think that the Austin case is distinguishable because at least in Austin, there was an attempt to affirmatively point the finger at somebody that was not a party to the suit, rather than just passively admit, okay, well, they're at fault too. But let's even assume, for the sake of argument, that comparative fault was sufficiently alleged in the first answer. It's clear that at the time comparative fault was alleged, that the city of Germantown was a party to the suit, and nobody has disputed that. That's an undisputed fact. Germantown was a party to this suit at the time of that first answer. And so where this takes us is, essentially, I think this case boils down to how do we interpret the town's decision, and what does towns mean when it says that you look to the point in time that the plaintiff either seeks to amend its complaint to name the additional comparative tortfeasor or files a separate complaint against the additional comparative tortfeasor. Well, if that's the case, I would suggest to the court that towns actually gives us more time than what counsel is suggesting. Counsel would somehow want this court to perform some sort of intellectual gymnastics by retroactively taking us all the way back to that first complaint that was filed 2 years ago and say, okay, well, now we're going to retroactively say that because now for the first time we've got a situation here months later where the city of Germantown is not a party to this suit, and now we're going to go ahead and create this legal fiction that retroactively takes us back to the earlier filing of the first answer. It seems to me that is too onerous of a burden to put on any plaintiff, particularly when the very purpose of 20-1-119 is remedial. This is a remedial statute. In fact, towns rationalizes its decision, it prefaces, in fact, its decision on the fact that 20-1-119 is remedial, and at the point of that statute is not to preclude causes of action, not to use it offensively.
Counsel, the first answer in which comparative fault is raised as to a non-party, and for the purpose of this question, I want you to, I know you're arguing against it, but let's assume that the first answer had raised comparative fault. The first time we have an answer that raises comparative fault as to a non-party is the second answer.
That's
right?
correct.
And the filing of bringing them back into the case was within 90 days.
Correct. Which makes this case really on all fours with the Scales decision. I see this very court, the middle section of this court, decided Scales. It wasn't published, but I suspect it wasn't published because nobody attempted to take it up to the Supreme Court. But I suspect that if it had been taken up to the Supreme Court, I suspect that Scales would have been affirmed because it's about as clear as you can get. This case is, and even counsel has conceded that he sees no daylight between what we have in this case and the Scales decision, other than his argument that Scales was wrongly decided.
The reference in the statutory provision, section 21-119A, to the within 90 days of the filing of the first answer, a first amended answer alleging that person's fault. is it appropriate to read that person as referencing the prior language, a person not a party to the suit caused or contributed to the injury or damage for which the plaintiff seeks recovery?
Yes, I think the totality of the statute is considered as to be construed in a way that makes logical sense. And it doesn't make logical sense to segregate it out. I think you're supposed to read the statute together. You're supposed to construe the statute as a whole. Clearly, that is what they are referencing. They're referencing the party that is being alleged to have committed the comparative fault. Otherwise, the statute wouldn't make any sense. So as I said, Scales is exactly on point. And the Towns case, and I, with all due respect to counsel, I just don't think that, I don't see how where do we go with his assertion that the Towns, if you go back, if the person's status as a party is when the complaint, when the plaintiff seeks to amend the complaint, then what we have is a much later date, and we have the city of Germantown at that point being a non-party. They're a non-party at that time. They become a party after that amended complaint is filed, obviously. But at the time that the amended complaint is filed, within 90 days of the first answer alleging comparative fault, the city of Germantown, at that point in time, and I would submit for the first time, is a non-party to this case. The city of Germantown remained a party to this case until the order was entered allowing the non-suit of the city of Germantown. And very shortly after that non-suit was filed, we went ahead and that's when the Willards amended their answer to alleged comparative fault against the city of Germantown, at which point we then filed our amended complaint as of right under 20-1-119. And so, if anything, counsel's argument extends our time. But there's another case that I probably should have addressed it a little bit more in my brief. I alluded to it, but not nearly enough, and it's the Mann case. And in that case, it was decided, as I recall, about a good decade after the Towns case. I believe Towns was decided in 2001, and the Mann case, Mann versus Alpha Tau Omega Fraternity, was decided in 2012. And in the Mann case, they specifically adopt the reasoning in Towns to give the statute a remedial effect, to allow the cause of action not to preclude it. And what we have I'll just read some of the language in the Mann case. They say the statute allows a plaintiff to add a comparative tortfeasor as a defendant after the statute of limitations has expired when two conditions are met. The first condition is that the plaintiff must assert a claim against a potential tortfeasor within 90 days. We have that of naming that person by a defendant sued within the statute of limitations applicable to the plaintiff's claim. The second condition is the person named must not already, they use the word already in that decision, must not already be a party to the lawsuit. Well, when we get to that first answer, the city of Germantown was already a party to that lawsuit. Germantown is not a party to the lawsuit on the later date, by the time that the Germantown is dismissed with the order of non-suit. So what the Mann court, the Supreme Court in Mann said that the dispute in their case was whether or not the appellees remained parties for purposes of section 20-119 when appellees were dismissed from the lawsuit pursuant to a written but non-final order. Now, I'll agree that the facts are slightly different because the key fact in that case was whether or not we were dealing with an interlocutory order or a final order. And they said it really doesn't matter. The point is, whether a defendant, they said that whether a named defendant ceases to be a party to the suit for purposes of 20-1-119, upon entry of a written but non-final order of dismissal is an issue of, they called it an issue of first impression before the court. And they said, we must decide therefore when a person is no longer a party to the suit for purposes of that statute. And they concluded they actually cite Sunbeam, stating that, referring to the language in Sunbeam, they state that the Court of Appeals reversed the trial court's denial of the Towns' motion to file a third amended complaint, however, because Sunbeam status changed as a result of the trial court's decision at the September 26 hearing. There was no dispute that the Towns' had attempted to file their third amended complaint within 90 days of the allegation of fault against Sunbeam by Manchester, a defendant sued within the statute of limitations. And they say, since the Towns' claims against Sunbeam had been dismissed, Sunbeam was no longer a party when the Towns' moved to file their third amended complaint. So Towns, I think, was more about the remedial effect of the statute, because I think, as I recall, and I think I may have briefed this, Sunbeam was technically a party because a hearing had taken place, but I believe the order had not been entered yet. What Towns recognized was that status, Sunbeam's status changed by virtue of the entry of that, the later entry of that order, and so they just said, we're going to give this remedial effect. We're going to say that Sunbeam was technically not a party at the time. And so, so what they said that we reached this, and then going back to Mann, we reached the conclusion based on the history and purpose of 20-119 discussed above, as well as our many opinions liberally construing this statute and the impracticality of a contrary rule, which, and then they discuss it below. And ultimately, they conclude that this was properly filed. And so, if anything, the Mann decision actually clarifies Towns, I believe, in a way that actually makes our position more favorable. Any questions? Okay.
Thank you.
Thank you.
Your Honor, the issues that plaintiff's counsel cited from Mann, or relying upon Mann, looking at the Mann case, in Mann, the Supreme Court recognized that Tennessee Code annotated Section 119 requires two conditions to be met in order for it to apply. First condition is that the amended, or that the plaintiff amend to name the added tortfeasor within 90 days of that comparative fault defense being raised, and then the second, that the added tortfeasor is not already a party. This case fails on the first condition. The plaintiff did not amend within 90 days of the first answer raising comparative fault. The significance of Towns is that the trial court used the fact that the city was a party at the time the Willard's original answer was filed as the basis for disregarding that answer as triggering the 90-day provision and using the second answer instead. That violated the Towns opinion, and it violated the clear language of Section 119, which requires the complaint be amended within 90 days. That error by the trial court is the same error that the Scales decision contains. Scales is not reconcilable with Towns. Towns, once again, said that yes, the added tortfeasor cannot be a party, but you determine that when the amended complaint is filed, not when the answer is filed. In other words, the fact that the city was a party when the original answer was filed is immaterial to triggering Section 119. If the answer alleges comparative fault, even if the comparative tortfeasor is a party at the time that the answer is filed, that is sufficient to trigger Section 119. Subsequent to Towns, the Court of Appeals in Queens Tree Surgery versus Metropolitan Government of Nashville and Davidson County echoed the Towns opinion, reaffirmed that that was the guiding ruling, and it did so in the context of a case that was similar to Towns in that when the answer, that case involved the Metro government. It was a property damage case. A non-governmental entity defendant was sued who was subject to a 3-year statute of limitations, and the governmental entity was sued subject to a 1-year statute of limitations. They were sued outside this 1 year from the date of the incident. The Metropolitan Government moved to dismiss. The plaintiff non-suited while that motion was filed because while the government was still a defendant, the non-governmental entity filed an answer alleging comparative fault against its co-defendant, the government of Nashville. Plaintiff non-suited them and then immediately turned around and filed an amended complaint adding them right back in. The government argued that that was not the intent of the statute, that you couldn't do it. The Queens Tree Court said you can because your status is determined when the complaint is amended, not when the answer is filed. Thank you, Your Honors.
All right, thank you, gentlemen. We appreciate your arguments. We will take this matter under advisement, review the record, and attempt to get you an opinion as early as possible. You may be dismissed. Thank you. Court will be in recess till the call of the docket this afternoon.
All rise.